Counselor, did you want to speak?
Yeah, just because my name was mentioned, Your Honor, and I make a representation to the court that I agree.
Well, first of all, let's tell us who you are. Make a record.
I made a representation to the court. I'm going to do this as counsel, as a member of the Prague Beachy Florida Bar, to both Ms. Anthony and Mr. Baez, that I would have rescinded my retainer agreement I reviewed pro bono, since I hadn't been paid anything anyhow, and there clearly was no expectation in the future. It was the same thing that I had in a case last year that I did in Tennessee for the Innocence Project, House versus Tennessee, and I donated my services pro bono. That was also a habeas capital case.
All right. Since you've spoken, any questions of Ms. Bond?
A couple of brief ones. Same question I asked Mr. Baez. Have you had any...
Hold on. You haven't been sworn, but you're an officer of the court.
Yes, as an officer of the court. I'm answering, Your Honor.
Have you had any conversations with any publishers, movie producers, photographers, magazines, anything else?
Absolutely not. I've handled a number of high-profile cases, and I don't think you've ever seen any book on any high-profile case I've ever done in the media.
On this one, you have not?
Absolutely not.
I mean, you had no discussions about any future deals, any future interviews, any future photographs?
Absolutely not.
Thank you. Let's wrap this up. Go ahead. Let's quickly take care of this, though. Go ahead.
No, 275,000. Yes.
That's been asked and answered. Any other questions, sir?
I don't think you can hear it, Judge.
Yeah, you may not have heard, but that's already been explained to the court. It's not a problem.
Yes. 10,000 went to Miss Marty McKenzie. No.
However you can do so, we'll take your money.
That was Mr. Mason. Go ahead, sir.
I'm sorry, I didn't understand that.
I didn't hear the question.
I think he's saying he would like the defendant to testify under oath to verify the information, if I understand correctly.
That's not what I was just...
Defendant's not going to testify on an oath for you.
I'm just translating.
Sir, if you want to repeat your question, I'm not sure I got it.
I think that form was executed the following day. They were filed at the same time simultaneously. They were just filed. It was submitted simultaneously. It was just done the next day.
Haven't we done this?
I think we covered that, sir.
I'm not sure on
He's asking
any
for
other
check
case.
anymore.
Did
What-
he get paid on
what
the
did you
check
say?
case?
No. That.
No. What else, sir? Let me just interject. She didn't delineate what was spent for what, but she testified that 100% of it went toward costs. Investigators, transcripts, travel. Anything else, counsel?
The itemization, I don't know, Judge.
Okay. I may have them submit that separately. They don't exactly know. I think maybe a breakdown is necessary. But any other questions that you have, counsel? If you want to submit any further argument, we just have some communication problems here. If you want to submit anything to me, just get it to me, fax it to me by the end of business tomorrow, and I'll consider it. I guess I'm just going to defer ruling. Any other argument by anybody here? Let me just you can wrap up if you'd like.
May I sit down, sir?
Yeah, absolutely, Mr. Mason.
Your Honor, there is no challenge to the evidence that this defendant is indigent now, or acknowledged she is indigent now. There is no money anywhere, the record is clear about that, to pay for any future defense for her. Those are undisputed facts.
Listen, I'm going to enter an order here of some kind. I'll rule specifically after anybody else submits, whatever they want to submit by tomorrow. What about rates and caps are associated with this? The Ninth Circuit has a schedule. Also, generally for experts, we try and get somebody here in Florida before we go out of state. What do you say about that? Yes. And specifically, I realize, I think I read somewhere here that you've developed a relationship with some people, but for instance, Henry Lee, we have a cap for experts. Are you going to deal with that if the court grants your motion? What if he gets paid?
Well, let me tell you this. Henry Lee told me one time at a National Association conference that he's done cases, been known to do so for a box of oranges. And Mr. Mason, will you send me a crate of oranges?
All right. The point here is there are caps and there are rates.
And we got lots of people volunteering their time, both lawyers and experts, but there are some expenses we have to have.
Okay.
In order to give her due process.
You get the court's point. You can't just
Yes, sir.
have somebody billing us and saying this is what we want. There are rates and caps,
And I would think that when we would submit an application, whether it's to you or you decide to appoint a special master to deal with it, then those fees would be vetted at that time as to whether they were reasonable and necessary, and they get paid. Nothing unusual about that.
All right. Thank you. Anything else from the staff?
Judge, I just asked that Mr. Baez provide you with the documentation that he says he can before you render your final order in reference to his documentation and itemization of the experts that have already
I think that's fair. The court will review it in camera and consider, a request to produce it later on. The amount paid to investigators, amount paid to experts. I don't need you to identify them. Just you can number them and.
I would like, what I'd like to do, Judge, if the court would consider is, if I could bring all of the paperwork that's involved in this case and Ms. Anthony's trust, present it to the court for an in-camera inspection. I have no objection to the state being present. Any questions that want to be asked? Actually, no, I do actually object to the state. Any questions that the court has, I certainly can answer as well. I don't know what more would clear things up. I think this is really, I want to be as clear and forthright with the court, and if there's any issues, I certainly want to clear them up so that the court has a full and complete understanding of where every penny went.
First of all, do you want to be heard on that regarding whether you can be present?
Well, certainly the JAC should have the ability to
Yeah, the problem is getting the JAC here, and I'll mull that over. So you have, sir, can you hear me? This is my final contact with you. If this gets scheduled, you do have a right to be here and to review what it is that Mr. Baez plans to show me, and we will coordinate that with you. And I would need, I would need a body here, though. I can't read it to you telephonically, though. All right? Okay, thank
And
you.
he'll pay for their travel expenses to come here.
All right. Final words? Okay. Yes, sir, not a problem. We're going to go ahead and hang up on you now, counsel. Thank you for being with us. All right. The only other thing is, this didn't involve Jack, so I got vision of supplemental discovery.
I filed that this morning based
Okay.
on discovery that I had provided to Mr. Baez on Tuesday. This was relative to the investigation that the court unsealed,
Right.
that I believe has been now released by the clerk or my office as public record.
Can we put some bench on that?
Why not?
Linda, will you come? Thank you.
If I join you?
And Jeffrey, I'm sorry. No, that's right. Two first readings.
We have last names, I think.
When a jury's here, please.
Name.
notice of provision of supplemental discovery filed by Ms. Drinkberg, and that includes a motion to delay release of some material. The motion has been unsealed. The motion's been made public. However, so that the defense will have an adequate chance to review it and respond to it, and ask the court to not release those items if they so choose. I'm going to order the state not to release the items referred to in their motion for at least 5 days. So hold it for at least 5 days, and Mr. Baez, the court's instructing the defense team to file any motion that you want to delay release, forbid release, whatever. And on this, if you're going to do that, we need to make sure that the media is notified so that they have a voice in this. So the court is not saying this will not be released to the public. In fact, I think it probably will be, unless you give me a good reason for it to be. But at a bare minimum, you have the right to look this over and let me know how it will be damaging to your client and argue for it.
Your Honor, for the record, it should also be clear that we suspect there are privilege matters in there that need to be raised, with attorney-client, word product, or otherwise.
You're not. You haven't waived any objections. You haven't reviewed it yet. So everything's on the table.
Judge, I think I thought we had 15 days, and then Your Honor said 5.
I said 5 days to file a motion. I may give you 115 days after that if I'm in a good mood.
I would ask for the 15, Judge, because quite frankly, it's a lot of material to review. In addition to that, we'd like to do some research on the matter.
Did you want to be heard on the time frame?
Whatever the court does.
I will give you 15 days to review it and file a motion. Again, whatever motion gets filed, you need to make sure we notice Sentinel Media so that they can be heard. All right, we're done.
Thank you, Your Honor. Okay.
I can say